Thank you so much for joining me on the show today.
Thank you.
So let me first start with you, Evans, and get a sense of what you've made so far of the process, the election tribunal process.
Well, that is the presidential election tribunal process.
Yeah.
Yeah, well, I think there's progress has been made so far because the court, in its wisdom, had given both sides the petitioner 10 days within which to present witnesses, and then the respondent 6 days within which to make up for the case. And then the petitioner has opened its case and has called witnesses. And those witnesses have been cross-examined, alongside the process. So right now, the case is open for adjudication. And it is through the presentation of evidence that parties are supposed to prove or disprove cases or assertions made during the process. And as it progresses, we all know that there's limited time within which to have this done. And I think both parties are working within the constitutional provision as regards the duration for which they are supposed to discharge the matter. So the larger picture is that Nigerians are watching in the world, entire world are watching to find out whether truly the President Muhammadu Buhari won that election and whether he was rightly declared the winner by INEC. So that is from where we pick it from.
All right, but Ken, I'd like to get your own contribution from the sense that I'd like you to speak on, what this process means for Nigeria's democracy going forward.
First of all, I actually wonder why there was so much delay in the startup of the presidential election tribunal. The main challenge Atiku filed his petition on the 18th of March. And if you look at it, that's about 4 months into the period since he filed his petition. We have 21 days after an election result is published for you to challenge that election. And if you look at the time it took between when we were talking about Bokachua recusing herself, who was the president of the Court of Appeal and the president of the tribunal, and the period in which she eventually recused herself, and the period in which she brought Gaba and the issue of the server, I think a lot of time has been lost. Why am I saying this? He has, like he rightly said, they've given 10 days to the petitioner to prove his case and 6 days to the respondent. But in my own thinking, having been one who has contested an election before and have been in the tribunal, for you to prove that in 11 states of the Federation, you actually are challenging the results in 11 states of the Federation, my thinking is that you should be able to present at least a witness from each of those local governments that are making up of those 11 states, from Kebbi, Kano, Katsina, Yobe, Borno, Bauchi, and all the other states that he's challenging, which are the main plank of the areas where Buhari was able to get those major votes that got him into 15 million margin, and he got over a little above 11 million. Now, is the time sufficient? The framers of the Electoral Act, the amendments that were done, were basically done so that justice can be seen to be done and done in time. And that is why you front-load your witness statements. And if these witnesses have front-loaded their statements, and you're only supposed to cross-examine, if all these issues were started early enough, that is, all these issues of Bokachua recusing herself and not recusing herself, they would have had at least 30 days to cross-examine their witness, and that would have given them enough time to send a clear case that either it was true that elections were manipulated, results were written, or elections were sent into servers, or servers did not exist. We could have gotten a clearer picture. So to me, I think we should streamline the processes.
All right, so streamlining the process. Do you agree on this one, Evans?
Yeah, I think that election matters of this nature, which are time-bound, that is why you won't have a constitutional provision. And then the Supreme Court have said this in Celestino Meyer versus Amechi, that the 180 days within which to discharge this process cannot be elongated, it cannot be moved. In fact, the Supreme Court went as far as saying it's like the Rock of Gibraltar or Mount Zion that cannot be moved. So now they are going to be rushed. And you know, the last time we spoke about it, the Bokachua recusing herself and all that, it took so much time because even PDP had to even write, the petitioner had to even write to her to remind her of the promise she made that day, that she's going to get a replacement and all that. So we must be a little bit serious with issues like this. This is the highest office in the land. And I expected that we should have had an expedited action on this particular process, given that our political stability determines our economic stability, and it determines the inflow and outflow of investors. So the way we go about it speaks a lot, not just for us, but for people who watch us and people who want to come down here and do business and all that. It is critical. That is why electoral reform is a major issue that will determine even the level of our economic growth, because without political stability, and that is why you have what they call political economy, which is a course of study. And then it is important that it is defined, the processes of election and then governance and leadership must be well defined and projected.
All right then. So looking so far at the process and how it has gone so far, one sticking point has been the fact that the legitimacy of both candidates have come to question. I'd like to give both of you the opportunity to speak on it. I'll start with you, Evans. You know, we've seen on the president's side, we're seeing the qualifications have been coming to question, and then on the other hand, Atiku Abubakar, people are talking around is citizenship. You know, I'd like you to speak on those, and if you think those are weighty enough to swing the case.
Well, in both sides, you have that relief, asking the court to disqualify, first of all, the current president because of the question of his academic qualification. But if you look at the Constitution clearly have stated what it is. If you have made attempt, the secondary school certificate examination, the Constitution didn't even say you ought to have it if you have made attempt to and all that. But if you look at it, much more than just the qualification is what was filled in the form. Okay, that is the current president. Okay, and that is CF001 form. Okay, that in 2015, that there were a lot of discrepancies in it. Now, if you look at it vis-a-vis what he said he had, that a lot of discrepancies for which the court must look into it. It is weighty enough because there are instances where the court have come to conclusion, because qualification is the baseline. Okay, so if there is falsification, okay, or if there is, remember that these things are done under oath, okay, and then you depose on affidavit to that effect. So if it turns out to be false, it is fundamental. It is fundamental to a case and all that. Then if you look at the other side, that is the side of the former Vice President Atiku Abubakar. The question of whether he is not a Nigerian or a Nigerian has been, a lot of commentary has been on that.
Let me bring in Ken to tweak on this, because he was making some points earlier on that I would like to hear him buttress on these points.
Okay, basically what the president's lawyer and the APC team are alleging is Atiku was born in Jeddah, and as at the time he was born in Jeddah, Jeddah was a part of Cameroon. You know, it was a plebiscite that was carried out in 1960 that actually saw Cameroon and Nigeria, that part of Cameroon and Nigeria fused together, and that became part of Gongola state, which eventually metamorphosed into Adamawa state today. And the Constitution says that if you are to run for an election, you must be a citizen of this country by birth. The thing now is that this thing has not been tested in court. And I don't think anybody can say that a man that has been the vice president of this country for 8 years cannot be said to be a Nigerian. But when you look at the semantics, if you read the Constitution that says you must have been a Nigerian citizen by birth as at the time of your birth, it calls the question for the judges or the lawyers or the judges to determine the interpretation of that provision. If they can now say that Atiku was a Cameroonian as at when he was born, even though his parents were Nigerians, I don't know if Cameroon was giving out passports just like America. When you're born in America, you automatically get the American passports and you become a citizen of America. Don't forget that Obama also had this kind of crisis. But I don't think that the issue of qualification is very key. Just like he rightly said, in the issue of you must have at least been educated up to secondary school level. That is what it says. And in the case of PDP, they are saying that the forms that were filled, an article, the forms that were filled by Buhari in 2015, his CFO and his CFO now, that there's a clear distinction between them. And you know, the CFO form, like he said, is an oath form. It's clearly at the end of the form, you see the court process that you need to take it before a judge. It's only after a judge has signed it that it becomes authenticated. Now, if you're filling that form under oath, it therefore means that anything you say will be lying under oath to the contrary. And the Electoral Act, Section 31, 5 and 6 is very clear. 5 says that anybody, not even PDP, not even Atiku, anybody that has any reason to question your CFO one, to see that anything you filled is contrary or is a lie, Section 6 says can approach either a federal high court or a high court. And if the judge finds that anything you said in that form is a lie, the person stands automatically disqualified. So those are very weighty grounds. But I think if I were to be the judges, I'd rather go into the merits of the case at this, because it is very sensitive. I'd rather go into the merits of the case at this particular point in time. How much they can present in 16 days, 10 days for the petitioners and 6 days for the respondents, leaves a lot to be desired from my perspective. But 180 days is what they have. So from March 18th to probably August 18th, if I'm right, or September 18th, that case, September 18th, that case, the judgment must be given.
All right, now, so very quickly, so let's just wrap it up because we don't have so much time on the show anymore. But I'd like you to speak to the fact that, so you think going through this whole process is more or less a victory for Nigeria, a victory for democracy?
Oh yes, because at least we didn't go to the streets. You didn't see them. I mean, you know what happened in Kenya. Even before they nullified the elections, you saw the destructions that had gone on in Nairobi. You saw the dead bodies that were on the road. The fact that at least we did not go into the streets, it's a victory for democracy. At least let us continue to improve on our electoral process, and especially our court processes and our tribunal processes.
Evans?
Yes, I think it's a good one because it shows that democracy is growing and that we're relying more on the rule of law and the rule of jungle, because Nigeria is a civil society and ought to be seen as such. But my problem with the two contestants in this tribunal is both parties are raising a lot of pre-election matter. I don't know what the Supreme Court is going to be sub judice. We can only just make reviews, okay? But a lot of pre-election matters are on both sides. Matters that ought to have come before now. You understand? So I wouldn't know how the Supreme Court will go, but the Electoral Act is clear and the Constitution is clear.
I think Section 285, 9 and 14 will apply.
Okay.
But there's an amendment that says that any matter that you don't bring within 14 days,
Yeah.
so when it comes to your notice, stands discarded.